In breaking news, we've got a new permanent injunction, meaning a permanent block after a federal trial issued by a Trump-appointed judge in Oregon, Judge Immergut, to permanently stop Donald Trump from deploying the National Guard on the streets of Portland, Oregon, and taking over the National Guard from mobilizing, commandeering, and then deploying them, because the facts on the ground, the truth on the ground, does not support him taking over the state militia, violating constitutional principles, violating the delegation under narrow principles of the ability of Congress to call up an army given to the president under certain circumstances under 10 USC, United States Code 12406. She found none of those elements were present to empower the president under the facts that exist on the ground in real life in Portland support that takeover. She's not declaring that he can't ever try it again if the facts do allow it, if there is a rebellion, an organized, armed resistance to federal officers and law. She's not saying that. She's saying that if there is facts on the ground that support that rebellion or support the inability of the federal government to execute laws using the regular forces, either federal officers already on the ground or the federal military, she'll revisit the issue. But for now, under the record before her, developed in 3 days of testimony, he's blocked. And it's important. I mean, this was a week, and I'll do a separate hot take about this. This is a week where Donald Trump lost 8 times, soon to probably be 9 times, in federal courts, with juries ruling against him, magistrate judges, federal judges, chief judges from Rhode Island to Oregon, from sea to shining sea. But this one I think is very important because there's so much going on with Donald Trump's attempted muscle flex and undermining the brand of the Democrats by going into Democrat states and cities only, not going into red cities, not going into red states that have high murder rates and violent crime issues and meth issues. But going into blue states to try to embarrass his political rivals and using the militia and the takeover of the militia, which would make our founding fathers and our framers, as Judge Immergut pointed out, to spin in their graves about what he's tried to do as an overgrown president trying to use effectively a standing army, which is a road and a path to tyranny. Let me read to you from Judge Immergut, again, a Trump appointee. And she's not to be trifled with. I mean, no federal judges. I've been practicing federal law in courts for 35 years. You wear that robe. Sometimes we joke as the lawyers on this side of the bench, and members of the bar, that judges sometimes have black robe disease. But you don't trifle with a federal judge, and not this one. This judge is seasoned. It has the gravitas, has the body of work to back it up. She'd been the U.S. attorney for Portland, Oregon, working closely with law enforcement. She'd been an assistant U.S. attorney in L.A. She'd worked in Rhode Island for the Department of Justice. She's done it all. I think she was a magistrate judge before she got appointed to be a judge. So she made her findings of fact and conclusions of law. Donald Trump tried to stampede her into a decision. She issued about 4 days ago, you might be thinking this is a repeat hot take. It's not. She issued a preliminary injunction to continue to keep the troops in their barracks because they're already in Oregon. And he already tried to send in other troops from Texas and California, and she grounded them. And the Ninth Circuit Court of Appeals ultimately, kind of in their own way, procedurally upheld her, because they, the Ninth Circuit, with a majority vote of 29 of the total of the judges of the Ninth Circuit, vacated or threw out a 3-judge panel of the Ninth Circuit that had ruled against Judge Immergut's temporary restraining orders. Remember, or let me tell you for the first time, administrative stay lasts for hours or a day or two. Temporary restraining order on similar facts as the other injunctions, but it has to do with time. It lasts a shorter amount of time. It's a temporary restraining order. Once the judge decides that the party in front of them is likely to prevail on the merits of the case. It will be irreparably harmed if this thing isn't stopped or blocked. It has an inadequate remedy law. The balance of equities tips in their favor. Those are the factors. Then from there, they expire by their term, by their order. after a certain amount of time. They can be extended, but then you move into a preliminary injunction, which is an injunction for the duration of the case until trial and final order or judgment or verdict of a jury. And that usually happens after a several-day hearing. So she had an evidentiary hearing to rule finally at the end of the case. On a permanent injunction, she asked the Trump administration to let her have a few more days, a week, to draft her order. It ended up being 106 pages, and Trump said no. The Department of Justice said no. So she had to order a preliminary injunction, which she did about 4 days ago. They forced her to do it. She said, I'm going to issue my order on Friday by 5 o'clock Pacific time. And she did, right on time. And here it is. I posted in Legal AF Substack. Judge Immergut. Let me read to you from the parts that were meaningful to me. She says at the very beginning, in her introduction on page 2, after a 3-day trial that included the testimony of federal, state, and local law enforcement officials and hundreds of exhibits describing protest activity outside the Portland ICE building, Immigration and Customs Enforcement, the evidence demonstrates that these deployments, the takeover, commandeering of the National Guard, which were objected to by the governor of the state and not requested by federal officials in charge of the protection of the building. Stop right there. Even the people running the ICE building who are feds didn't request the National Guard. I think that's a very telling piece of evidence. She said all of that, rolling out, trying to commandeer the Oregon National Guard or send in other National Guard, exceeded the president's authority. While violent protests did occur in June, he didn't send the troops in until September. They quickly abated due to the efforts of civil law enforcement officers. And since the brief span of a few days in June, the protests outside the Portland ICE facility have been predominantly peaceful. I'm going to show you some B-roll here, like we like to say, some video of the peaceful naked bike protest. Chickens and people in chicken suits and in frog suits, while Kristi Noem was looking from the top of the ICE building down at the 12 people that were standing in silent protest at the bottom. The judge says there was only isolated and sporadic instances of relatively low-level violence, largely between protesters and counter-protesters. That's not stopping the feds from executing their immigration law. Under the Constitution, Congress possesses the power to call up the National Guard to execute the laws of the Union, suppress insurrections, and repel invasions. Under Article 1, Section 8, Clause 15. But Congress delegated that power to the president under certain circumstances under 10 U.S.C. Section 12406. But they still, unless properly executed, they're always the state militia under the command of the state governor. The president's unlawful federalization of the National Guard, she ruled, this is a final order, violates the 10th Amendment, which reserves to the states any powers not given to the federal government in the Constitution. It is our sovereignty, state sovereignty protection. She then goes on to talk about the Supreme Court and some of the founding fathers. She says on page 4 of her order, on the top, this court acknowledges that some citizens may support these deployments as a helpful military supplement to effectuate the president's immigration agenda. Yeah, just a helpful military supplement of an out-of-control, tyrannical president to put a standing army on the streets of America. But she's being polite there. But the founders, quote, embodied their profound fear and distrust of military power in the Constitution and in its amendments, which has lived on through the decades, demonstrating a traditional and strong resistance of Americans to any military intrusion into civilian affairs. She says, as she's going through the evidence, she said, first of all, there's very little, if any, violence against federal officers. There were a couple of incidents. They were quickly handled and dispatched by local law enforcement and federal officers. They didn't need the National Guard to fix it. She said most of the issues outside early on in June were protests versus counter-protesters. It didn't stop the ability of the president to execute under the laws. There's only two elements, there's only two conditions that Trump has tried to claim were present in order for him to take over the National Guard in all these states. A rebellion, and Judge Immergut rejected rebellion. She said that is a defined term from our history. It has to be organized, it has to be armed, and it has to be a resistance of a certain level, a certain pitch of violence. None of that was present. She went through pages and pages and pages of evidence and testimony about how this was not a rebellion. I don't even think the Trump administration believes it was a rebellion, although they may argue something different to the United States Supreme Court. But let's take rebellion for a minute off the table. I mean, they couldn't even agree during the immunity oral arguments at the Supreme Court 2 years ago about what an insurrection was. They're not going to agree that a bunch of people in chicken suits yelling and screaming at ICE officers is a rebellion. So now you're left with, can the president execute federal law using regular forces? Now, the issue of regular forces, you'd think after 250 years of history would be defined. It isn't. And so she does a nifty trick in her order, Judge Immergut. She says, I don't have to resolve what are regular forces. The Ninth Circuit has said regular forces are federal forces. Like, can you execute the laws using your own feds? If you can, which she says they can, then you never get to tap back up from the National Guard of the state. You never get to take over, cross the line, violate state sovereignty, and take over the National Guard. It's a big deal, a heavy lift, and you're not able to do it under those circumstances. Now, the Supreme Court, as she noted, is currently struggling with what the term regular forces mean. And they've asked for additional briefing because they're about to take on some of the National Guard cases through a Chicago ruling that's up in front of them about whether it was appropriate for Donald Trump to take over the National Guard in Chicago. Now, we'll get some guidance from the Supreme Court about future takeovers once they rule. But they are also troubled by what are regular forces and what do they mean? I mean, there's two arguments from our history going back to the late 1700s that regular forces mean the armed forces, the army. You send in the army. And if after sending in the army and maybe your federal officers, and they're still so overwhelmed, there's like a siege, it's like the Alamo, then you can call in the National Guard, but only under those circumstances. And those circumstances obviously were not present. They were not on the ground. These people were not overwhelmed. Maybe it took them a little bit longer to get some migrant that they picked up without due process and shove him into a van and drive him into the ICE facility. But, that does not allow a president to call up a standing army on domestic soil. And she's very focused in her order about how the violence might have been present in June, but by the time he rolled it in September, it was long gone. Here's what they said. This is what she says on page 69 of her order. The limitations placed on a president's ability with a delegated duty to call up the National Guard reflects the founders' understanding of the scope of the calling forth power to execute the laws of the Union, which is again in the Constitution, Article 1, Section 8, Clause 15. At the Virginia Ratifying Convention in 1788 of the Constitution, a delegate thought the word insurrection included every opposition to the laws and asked whether the militia clauses could omit the phrase to execute the laws of the Union. In response, James Madison clarified that a riot did not come within the legal definition of insurrection. There might be riots to oppose the execution of the laws which the civil power might not be sufficient to quell. Alexander Hamilton similarly understood the clause as allowing the federal government to command the aid of the militia in those emergencies which call for the military arm in support of the civil magistrate. And then she goes on and says on page 70, pulling again from the founding fathers, from the patriots of America that helped at its founding, she says, perhaps the most illuminating from the Virginia Ratifying Convention is Governor Edmund Randolph's response to Patrick Henry, warning of the apparent wide breadth of circumstances in which the militia could be called forth to execute the laws. As Randolph stated, It is supposed that the clause for calling forth the militia to suppress insurrection, repel invasions, and execute the laws of the Union implies that instead of using civil force in the first instance, the militia are called forth. So you just skip a step and go right to the militia. Ought not common sense to be the rule of interpreting this Constitution? Randolph asked, is there an exclusion of the civil power? Does it provide that the laws are to be enforced by military coercion in all cases? No, sir. All that we are to infer is that when the civil power is not sufficient, the militia must be drawn out. So that suggests that if you try your federal forces, and there's a lot of federal security forces around ICE, in combination with maybe the armed forces, the military, and you still can't do it with the feds, then you tap the National Guard, but not before. So this is a big ruling. It's the first permanent injunction related to the National Guard. The other ones coming out of Chicago were temporary restraining orders and or preliminary injunctions. And it's going to now form this body of context for the United States Supreme Court as they rule in the next 30 days or so about this use of the National Guard by Donald Trump. And what we're worried about on this side of the microphone and on this side of the audience is that Donald Trump continues to use this muscle flex in a tyrannical way to suppress dissent and First Amendment rights. We won't allow it. Tuesday, we sent a clear message that Trump is on his dying days, the waning days of the Trump administration. We're making him as lame duck as possible, as soon as possible, less than 1 year to the midterms. I'll continue to follow it all right here on Legal AF. Thanks for being here on Legal AF Saturday. You could be doing a lot of other things today, and I'm glad you're watching this video. We appreciate you. Hit the free subscribe button. Come over to Legal AF Substack. Do the exact same thing. And if you can swing becoming a paid member, people say, how can we support Legal AF and keep it on the air with all the contributors and the work and the interviews and the newsmakers and the lawyers and all of that? How do we do that? For $6.77 a month, we'll give you the content and you give us the support. And that helps pay for the honest commentary and journalism that we do here. So until my next report, I'm Michael Popok. Can't get your fill of Legal AF? Me neither. That's why we formed the Legal AF Substack. Every time we mention something in a hot take, whether it's a court filing or a oral argument, come over to the Substack. You'll find the court filing and the oral argument there, including a daily roundup that I do called, wait for it, Morning AF. What else? All the other contributors from Legal AF are there as well. We got some new reporting. We got interviews. We got ad-free versions of the podcast and hot takes. Where? Legal AF on Substack. Come over now to free subscribe.